Jim, how will Prop 3 affect parental rights?
Well, I kind of think we need to first look at what kind of rights parents have with regard to giving consent to their minor children's medical treatment. Now, in Michigan, the general rule is that parents have the right to provide for the care, education, and control of their minor children. We do, however, have some statutes that make some exceptions. One statute relates to a pregnant child, a minor that's pregnant. We have a statute currently that says that a minor child is not, who is pregnant, is not required to obtain parental consent for medical care for her and the fetus, but there's a restriction on that. It has to be to maintain and protect the life of the mother and the fetus. And so long as we have the care for that minor and the fetus, as long as protecting and protecting their lives, parental consent is currently not required. And if anybody wants to read the statute on that, that's found in the Michigan Compiled Laws 333.9132. It's also my understanding that currently, because of court decisions, a minor does not have to obtain parental consent in order to obtain contraceptives. And here I'm relying primarily on the case of Doe versus Irwin, which is from the Sixth Circuit Court of Appeals. That's a federal court of appeals. And it's found in the Federal Reporters at volume 615, page 1162. So what I would say at this point is that currently a minor does not need parental consent in order to obtain contraceptives. A minor who is pregnant does not need parental consent to obtain prenatal care or care during the pregnancy or even postnatal care, so long as the health of the mother and the fetus are being protected during that during the medical care that she's being provided. Now that, of course, would not include an abortion because an abortion does not protect the life of the fetus. We have a separate rule for parental consent with regard to an abortion. With regard to abortions, minors are required to have parental consent. Actually, what it is the health care provider, before they can do an abortion, have to have the consent of both the minor and a parent, or in the alternative, in the alternative of having the parent's consent, you can get a probate court to waive the requirement of parental consent. So abortions are treated differently. Now the rule requiring parental consent for a minor's abortion, if anybody wants to look it up, can be found in Michigan Compiled Laws 722.903.
Okay.
So that's kind of how our laws are currently set with regard to whether or not a parent is required to consent.
So we already have laws on the books, as you stated, that give a minor the ability to get pregnant and effectuate that pregnancy all the way through term without even ever consulting their parents. That already exists in Michigan. And there is an avenue for a child to obtain an abortion, let's say, if one of her parents, both of her parents, will not consent to the abortion. Say there's something going on that's requiring or making it so the parent will not consent to that. But the child wants to, they can petition the court, and the court will make that happen.
Correct.
Okay. How does Prop 3 change that as far as moving forward if this passes?
Well, I don't see how it would change at all the statutes relating to care to maintain and protect the life of the mother and the fetus. Where I think it's going to come into, or where it's going to have an effect is on the requirement that the parent give consent for a minor child. Now, and there's two reasons. Well, I guess there's really one reason applied in two different ways. Under the proposition, recall that under Section 2, I think it is.
Yep.
Well, okay, why don't you go ahead and remind us what that says?
Sure. Section 2 says the state shall not discriminate in the protection or enforcement of this fundamental right.
So what we have currently is we have care that we don't require consent, where the care is to protect the mother and the fetus.
Right.
Where it's not for the protection of the fetus, where there's an abortion, then we currently require parental consent. So you see, abortions are treated differently than other care that's provided as part of the reproductive freedom. So you have discrimination there. You're treating abortion differently. I think no longer could you treat abortion differently because discrimination is prohibited.
And we're kind of relying there on the idea that in Section 1, it says an individual's right to make and effectuate decisions about all matters relating to pregnancy, including but not limited to abortion care. And so the idea is that that fundamental right is extended to every individual, and the discrimination would come now, if you, from what you're saying, based on if you parcel out the health of the mother and the fetus versus abortion, which is only for the health of the mother.
Right. In other words, you're treating abortion differently than you are childbirth. You're treating it differently than postnatal care and prenatal
Contraception, sterilization.
Contraception, and those things.
Okay.
So you're singling out abortion, treating it differently. You're making it more difficult for a minor child to obtain an abortion by requiring parental consent or a waiver from the probate court. That discrimination burdens the right, and so I believe that the parental consent statute that we referred to with regard to abortion would violate the Constitution because of the discrimination. One other aspect of the discrimination is it treats, as we mentioned before, 15-year-olds different than 18-year-olds, so it discriminates on the basis of age. Now, normally we do that in a lot of circumstances. If you go to get a driver's license or a hunting license,
Go to buy cigarettes.
we discriminate based upon age. However, this doesn't say that you can discriminate on on age or certain things. It just says you shall not discriminate.
Yeah, well, and it shall not be denied, burdened, or infringed, and you shall not discriminate in the protection of the enforcement of this fundamental right.
So, to me, that says you can't discriminate on any basis, including age. So, for those two reasons, I think that probably the statute that requires parental consent or waiver from a probate court does not comply with the requirements of this constitutional amendment. And of course, as we mentioned before, if you've got a conflict between the statute and you got between that and the Constitution wins.
Every time.
Yes, that's correct.
Do you think there is a potential for an age limit to show up? Right now, it says you shall not discriminate, right? And we talked about discrimination based on age in the Elliott-Larsen Civil Rights Act. But do you think that could come up to where that would get limited, and could the legislature in the state of Michigan pass a bill that would limit it to, say, 15 years and older? This is hypothetical.
You know, that all depends upon that definition of a compelling state interest. If you could say that there is a compelling state interest for the health of the child, the minor child who is pregnant, if there's a compelling state interest to have the parents consent to the abortion for the health of the child, well, that's part of it. And the other thing is you'd have to say that a child does not have cannot make an autonomous voluntary decision. To me, it would be pretty hard for the legislature to come up with anything that would require parental consent in the case of an abortion.
Could it also be argued that potentially the state is trying to step between the parents and their child in this moment For example, the state may be able to formulate an idea of a compelling state interest to protect the health of the child, but why is it up to them to determine that? Why would it not be up to the parent to determine the health of their child?
I don't think the parents' rights don't come into play with regard to the definition of a compelling state interest. Now, in the past, it's been noted that parents have a fundamental right with regard to the care of their children. But this here seems to, if this is adopted, it's the people of Michigan are saying, with regard to abortion, the only compelling interest is what we say it is here. And it does not include the rights of the parents to have notice of what's happening to their minor child or to have to give consent to the treatment.
Well, it really seems like this amendment will greatly change and affect a parent's say in their child's life when it comes to abortion. Please read the full language of this constitutional amendment and know what it is you're voting for this November 8th.